Cheers, guys.
Cheers. And the three clinks.
To a variety of very interesting cases. Every case is unique.
Well, this comes out of the context. You're going to lead with this.
I'm going to lead on this because it's a topic near and dear to my heart.
So we just finished a Superior Court trial this week on a sex assault arising out of a divorce, where we actually called expert evidence of the accused, who was our client, a man, being abused in the marriage. So akin to the battered wife syndrome, it was the battered husband syndrome, and we'll talk about that at a later date, but it was the intersection between family law and criminal law that brings us to this.
Right, so family law, we've noticed a really disturbing trend. It's basically...
You have a lot of experience in family law.
I've done a bit of family law, so I've had some first-hand experience. Family law recently is being weaponized and used in the criminal system. And we're slowly learning how to respond to that by getting the documents from the family law cases. But another disturbing trend, and we'll get into the other topics in a minute, is a recent judgment from Ontario Superior Court of Justice. It's Ahluwalia, Ahluwalia. It's from February 28th of 2022. And this case is disturbing. This case recognizes the tort of family law violence. Put simply, that you can claim damages for a history of family law violence arising out of a relationship.
Which would normally be a civil case that you'd have to bring separately.
Right. And get compensated for in the family law courts. In this case, the mother, she responded, she self-represented herself and did not a bad job, because at the end of the day, the judge said, I'm prepared to award $150,000 in compensatory, aggregated, and punitive damages for the tort of family violence. And as the judge himself recognized, he said, this is a significant damage award because it's well outside of the normal boundaries of family law. This doesn't happen. So this is a scary trend, a major change that's happening.
Yes. So what was at issue here in the family proceeding was property equalization, child support, spousal support, and the mother's claim for damages for the father's alleged abuse during the marriage. And she recognized in this proceeding a rationale for the tort of family violence.
Right.
So talk a little bit more about what that actually means. So because previously, if you wanted to claim damages for domestic violence or sexual assault, you could. There's always been a tort for battery or sexual assault, and you could bring a claim, a separate claim, and then that would be litigated on a balance of probabilities in the civil system.
And they'd be looking solely at the claims of the violence, as opposed to looking at the bigger picture of the separation.
Well,
but this has now brought it in because it's the tort of family violence. So what is this? Explain this a little bit more. What does this really mean?
So this means that in the context of a family law case, any history of...
Claimed history.
Claimed, and that's the key thing. It's alleged history, not convictions, not any sort of proven history. These are allegations, and in this case, the judge basically said, "Yeah, I accept your evidence that there's been a history here, as you claim of family violence." So it brings in a very discrete issue, as you said, of damages, and takes it into account into the whole family law settlement. So that means spousal, so it's now lumped in with spousal support, child support, and now we've got damages awards being made, which is unheard of in these types of cases.
So let's just distill this for one moment, because these are the findings of the judge. So this is one of those rare circumstances where the common law should recognize a new foundation for liability for family violence. I come to this conclusion based on the existing law related to spousal battery, explicit recognition of the harms associated with family violence in the Divorce Act, recent provincial legislation that removes other legal barriers facing survivors leaving violent relationships, developments in the American case law, and Canada's international obligations to women's equality. Now, all this is to say, domestic violence is real, domestic violence is harmful, and it causes lasting trauma to whoever is the recipient of it. Absolutely.
Yeah, no dispute.
But what we have been speaking about for now a couple of years on this podcast is how you can weaponize a system and gain tremendous advantages with very little evidence.
So
Right. Well,
that passage you read, though, that she talks, I think it's a female judge. I can't remember whether it was he or she. The judge says something about this being a new thing,
New tort,
right?
yeah.
So can we talk for a second about judicial activism and the separation of powers between the judicial branch and the legislative branch?
So what you're saying now is, here we have a judge essentially creating a common law liability in the family law sphere for family violence, as opposed to the Parliament, our federal system, where the Divorce Act is a federal act, amending the act to recognize within it a ground of damages for family violence. So that is where you have our government, who are elected individuals, to put a bill forward to amend an act, as opposed to a judge now concluding based upon a number of factors. And legitimately, it could be that family violence is recognized within the Divorce Act. And there has been some developments in the United States, and we do have international obligations related to women's equality. But what you could try and say here is the judge has created new law, and some may see this as judicial activism.
Mm-hmm. And I think I've mentioned this before on Wikipedia, which is not the best source anymore for neutral information, but there's a page that's specifically just about judicial activism in Canada. It's something that we need to really pay attention to, and to what extent it's taking place is subject to dispute, but we're one of the few countries that has a devoted page to the concerns about judicial activism in Canada. Mm-hmm. And there's a couple of different ways that law can be changed by judges. One is they create common law. The other is they change the way they interpret the law.
Right.
Now, let's be fair, though. The judge did rely on other case law and other developments in other jurisdictions. And a recent example in a case in Ontario, Montgomery, where Justice Healy awarded the mother $75,000 in damages for interspousal tort of assault. Case involved a 14-year marriage characterized by physical and emotional abuse. In that case, the judge found that the most significant aggravating factor was the flagrant breach of trust, but the judges could also consider the nature of the overall oppression and aggravating post-incident conduct, etc. So that was another case which was relied upon. So let's not just say this judge acted on their own.
No, you can see the thickness of the decision.
It's a well-reasoned, well-written judgment, citing a number of cases.
Well, but this is the thing with family court judgments. They tend to be this big because they're so convoluted, and it's so... In my takeaway quite often is just like, how did these people stay together for so long? It's unbelievable that people could...
As we and I discussed, used to be for the sake of the children. Let's stay together and hit each other's guts.
This is important. This is important because a lot of people who end up being charged, it has to do with their devotion to trying to maintain contact with their children.
Right. But let's read the test. This is the new test now. That all being said, this is at paragraph 55. To establish family violence, the plaintiff will have to plead and prove on a balance of probabilities that a family member engaged in a pattern of conduct that included more than one incident of physical abuse, forcible confinement, sexual abuse, threats, harassment, stalking, failure to provide the necessaries of life, psychological abuse, financial abuse, killing or harming an animal or property. It will be insufficient to point to an unhappy or dysfunctional relationship.
I just got so aggravated as soon as you said financial abuse, because I know that usually that phrase is used to describe a person who has no income on their own, and so they're subject to the person who has the income doling out small amounts of money or cutting them off from finances. Right. But there's another kind of financial abuse that I've seen, which is where one spouse overspends and causes the other person to not be able to stop working and puts them into debt and causes them extreme stress.
The flip side.
So a lot of these phrases, they're used specifically to describe alleged abuse against women, and it's supposed to be a crime that's primarily committed against women. But when you get into these subtle things like financial abuse, they're opening it up because, you know what I used to do? I know so many men who've been subjected to coercive control, financial abuse, things like that. And And we've seen a bill that was attempted to be passed where one of the concerns with the bill expressed by feminists was that women could end up being charged under this new legislation.
Right. And we frame this a little bit because we just finished this trial this week. We don't have a decision yet.
I know.
Where we had an individual who we actually did believe was subjected to manipulation,
We didn't just
coercive
believe it. There's a
control.
lot of evidence of it.
Right. And we got the person assessed, and there was a lot of evidence that we were able to gather through messages to look at as source collateral information to establish that this abuse of control existed, some of which was financial abuse on the male. And we'll see what the court does with respect to recognizing this injury and this actual issue in the case. But what's great is we actually got to call the evidence.
I know. And why? Do you remember? Justice Leheureux Bay.
Right.
She had written in a Supreme Court decision that she recognized that women weren't necessarily the only victims of battered spouse syndrome, but that if a man was claiming to be in that situation, it would almost always require expert evidence.
Yeah.
Because it's so poorly understood and poorly reported.
Not because it's so
poorly
rare,
understood.
just poorly understood.
That's right.
Understood.
And in this case, what's interesting also is the judge was cautioning about the same stereotype reasoning that's used to assess domestic or sexual violence in the criminal context. So the judge was talking about, again, analysis under existing intentional torts creates a risk that the triers of fact will miss the relevant social context to engage in stereotypical reasoning about the proper component and behaviors of survivors when assessing credibility. For example, they might speculate as to why a survivor of family violence would stay in an abusive relationship or fail to complain to police. Now, using the term survivor bothers me, but we see the same issue here with respect to how they're saying within the family law context, they're better able to understand the social and relevant factors at play than if you would in a separate action. Of course, though, however, family law cases are already now sometimes incredibly complex, incredibly long, take 2, 3, 4, 5, 6 years, maybe even longer, hundreds of thousands of dollars. You're going to now have to have medical evidence, experts called, and you're going to turn this into an extremely expensive system where it can be ripe for abuse. And I always thought that the idea of having a separate action and tort specifically focused on that would have a much cleaner trial, which a much cleaner focus, a bit devoid of this other context which they want to talk about, because that can cloud the truth-finding process, in my opinion.
Yeah.
And there's a lot of emotion, right?
Okay, so
Unbelievable.
We've talked about this because I have, through my nonprofit, get contacted by a lot of people that are struggling in the family court system. They're not criminally charged yet necessarily, but and I said to you, I have trouble getting involved with them because it drives people crazy.
Right.
And so then when we look at the combination where as a result of the separation in the family court argument, somebody gets criminally charged, it becomes, I find, really difficult to get people focused on the criminal charges because they're so obsessed and so angry about what's happening in the family court,
law side.
The family law side, that they can't focus and understand the seriousness of the criminal side.
Right.
Can we talk about that a little bit?
Well, we were talking about the playbook, right?
Yeah.
The playbook, how these things all start. You know, the relationship goes bad. How do you get typically the guy out of the house? You 911 him. He's out of the house. What do you do in the next weeks following? You get your family lawyer. You're getting your motion for, child support, interim spousal support.
Exclusive possession of the home.
Exclusive possession of the home. And you're playing games like with the potential client we saw the other day where access is being doled out as the parent deems fit, right?
Or denied.
Or denied. And then it turns into a whole playbook. And so now we've got the criminal system, family law system, weaponizing the criminal system, and then it's like a playbook, like you described. You've seen those online, you said.
Yeah, it's just an entire path to insanity.
Right.
Well, let's talk for a moment. Now that we know that this is recognized law.
Right.
So I think it's important for us to have talked about it so that we all recognize that it's there. And this will play out in the family system. And frankly, family lawyers will have to become very adept at now learning how to cross-examine on these issues without getting into myth-based reasoning and learning how to basically become a criminal lawyer in a family context. But from our point of view, for the last 20 years in, is my hair f***ed up or something? Thanks, honey.
Because he's had a long
sweetie.
day.
In the family, I have used and worked very closely. Thank you, honey. Worked very closely with family lawyers where there is charges arising from a high conflict divorce, for example, and have worked in tandem with the family lawyers. And there's an incredible richness of information that comes from family court documents to cross-examine on.
But also it's very important for another reason, because in the family courts, they have to file affidavits. And so
let's explain what materials are filed in a family court that then can be of great value to a defense lawyer. And then two, why is it important to get out front on the family side and the criminal side all at the same time?
And have coordination between the...
So let's talk about what happens in a family proceeding.
Let's start with the application. So an application is made for divorce. In that application, the person who's starting the process is setting out claims he or she is making. And it's very interesting to actually look at those claims because sometimes they're not based in fact or reality. I had a case recently where the woman had claimed damages now for therapy, for medical expenses on the family law side. On the criminal law side, I was cross-examining her at trial. I said, so how much have you spent on therapists? Nothing. How many therapists have you seen? None. And then I took her to the family law document. Well, you're making a claim for thousands of dollars for expenses that haven't occurred and probably will never occur. Isn't that right? And she was like, yeah. So it's critical to study what's being claimed.
Yeah, so that's incredibly interesting. Let's just talk about the application for 1 second, because it's a legal document. It's filed in court. It lays out all the factors in which you're relying upon and what you're claiming. So you'd be claiming for support,
child support,
distribution of assets, all that stuff. Yes. But you'll lay out what your grievances are, and then what you're claiming, and then you sign it. And it's dated and signed.
And there's a supporting affidavit. You have an affidavit. So you've got now...
Explain that for a second so everybody understands.
So when you file your family law application, your divorce application, you typically file supporting affidavits which set out the history you're claiming. What are you saying happened under oath? So that's a sworn document now, a public sworn document that we get access to if we're working in tandem with the family lawyer, which is critical, as you said, to do this together so we know exactly what's going on the family law side, because there can be contradictions that are key, as in my case that I just described.
It's a perfect example. So you've got this application that's dated and signed by the person, so this could be the complainant, and then there's an affidavit typically that follows, and then other documents like other affidavits, and there can be motions for, let's say, there's an interim motion for sole custody of the children. And then there's an affidavit.
Possession, as you said.
There's
or
an affidavit.
Separation agreements, too, if it's not a full marriage.
Later on. No, it's still a full marriage.
Right.
You still have a full marriage.
Well, I'm thinking about a specific case that we worked on.
Right, but just so we get the terminology.
Used.
Thank you. But so long as you get the terminology correct, you still have a separation agreement when you're married and you're divorcing. You have a separation agreement, and that can be turned into a final settlement agreement. All of these are incredibly important. All of them contain allegations. All of them rely on sometimes criminal allegations. And there's so many contradictions, so many exaggerations, so much bullshit in there that you can have an incredible amount of time.
And sometimes falsified marriage certificates.
Right. And the added
we had that in a case where the complainant, they weren't legally married, went to the extreme to falsify a marriage, which we caught.
And then, when it was determined that it was a falsified marriage certificate, refused to grant it, tried to refuse an annulment
of the false marriage.
Of the false marriage.
Wonderful.
So talk for a moment about...
And this all, but you brilliantly used that in the criminal process.
Right. And that's key.
And I was working with an excellent family lawyer where we worked in absolute tandem.
And and at the same time, the flip side of that is we have to protect our client and be very careful what he or she is putting in their family law materials. We don't want to get boxed in, or we don't want them to get boxed in their family law context, because then they are providing an affidavit. They're providing their story. So sometimes it's also helpful that they not provide that.
So let's say a client comes to you. They've just been charged. They're just separating from their spouse, male or female. and they're charged with a series of domestic violence, throw in a sexual assault. And they come to you and they say, okay, I need representation. What do you talk about with respect to the family case? Do you talk about it at the meeting? How do you handle that?
I tell them it's critical we refer them to a family lawyer that we know that we're comfortable working with, and that's going to work in tandem with us, because the documents that get generated are critical in the end. We need to know what our client is saying in those family law documents. We need to have conversations with his or her family lawyer to say, look, we got to work in tandem. We got to make sure the narrative, the story, whatever you want to call it, comes out consistently. We don't want two inconsistent stories in two different court systems, because that'll only hurt us. It can help us if it's the other side's inconsistencies.
Right, but on our end, it could be deadly.
Right.
If it's done
It's
improperly.
very similar to giving a police statement before
Right.
you really know.
It is,
what
because
the case is.
because
under
when you
oath,
sign
isn't
that document, I can't tell you how many complainants I've cross-examined on their application or on their reply, which is the flip side of it. You reply to it, the response, and they've said, well, that was my lawyer. I go, well,
That's
you
right.
signed each
You
page.
signed it. That's right. They
You
do
signed
that.
each page.
They do that a lot.
That's your signature. It's dated. You tell them you didn't read it, you're just, like, it's just, it goes nowhere. And
My family lawyer told me to sign this. Yeah, right. Under oath.
yeah, except all this information didn't come, your family lawyer didn't dream this up.
That's right.
Right.
It came from somewhere. So first stage then is when they walk in to say, look, if you don't have a family lawyer, you're going to need one.
Right.
And we have a number of lawyers that we work with we'd like to refer you to, because they're familiar how to work with a case where there's criminal and civil family law issues. So that's critical.
Right.
Once that's done, let's say they do that, then the next stage is what?
In terms of the family law, well, to work with the other lawyer and to ask for draft documents to be
there's
sent
a
to us, for
determin-
example. Sorry?
There's a determination sometimes whether or not they should, put off the family stuff until the criminal stuff is resolved. Sometimes, we've had the family court stuff resolved and it's assisted with the criminal thing. So that's why it's so important to have that communication.
Communication is key, but it's also sometimes difficult because there's deadlines for responses. So it's hard for us to tell a client, don't put in an answer just yet, because there's rules in
So,
family
there
law.
may be an issue about, do I start the divorce now? Do I
Right.
respond to it right now? How do I deal with it? But then there can be issues like there's children involved, there's parental alienation going on. So you have to respond. And in some cases, we've said, what, this should proceed, and you should go to a discovery. And we just sit back there and work with the family lawyer. And what's a discovery in a family case?
In a family law context, that's when both family lawyers get the opportunity to examine each other's clients under oath. So it's great for us because it's almost like a first kick at the can at seeing their potential evidence, A, and B, it sets up some great inconsistencies if they say something different under oath at trial. So it's
Can we use a discovery transcript from a family court case to cross-examine a complainant in a criminal case?
yes, we do it all the time,
I know.
and it's great because the inconsistencies are hilarious.
So, we had that one case we were talking about where we specifically orchestrated for that case to proceed.
Which issues to cross-examine on?
And we all talked about what issues to cross-examine on in the discovery. And then we took that discovery transcript, and it was almost like having a preliminary inquiry. We were able to rely on it for cross-examination. And then the case we just did this week, it was just funny. The
I was
complainant,
thinking about that earlier, yeah.
there was a separation agreement because we had got him over to a family lawyer and guided that process along, and then we were involved in when they were settling. But the separation agreement was wonderful because the complainant, who allegedly was not financially motivated, in the separation agreement it said, and at the time that this is settled and the money is transferred, the male husband shall pick up from the complainant and whatever they call it.
She'll transfer.
Transfer a number of documents that are in her possession.
And the nature of the documents is stunning.
It's stunning. So
And
there
she'd
was
held on to these for over a year.
Right.
So there's all his job-related applications and papers,
Passports, right?
His T4 slips.
all his immigration application, permanent status, his citizenship card, all his tax returns, his notice of assessments, gone.
His
His
diploma.
law degree. Yeah, I mean his not law degree. His university degree. His university
She
degree.
wanted some mementos.
It was literally trying to paralyze.
She refused to return them until the separation agreement was finished. It took over a year. He didn't even have his own immigration papers.
All of this was
All held
not
hostage.
even his degree, not even his. Oh, and took and she was residing at his home. They were married, so he put her on title. But when she moved to her brother's place, she changed the address for the tax notice to her brother's home so that she'd know what the taxes were on. I mean, this was incredible. And this happened within a day of when they separated, 3 weeks before she went to the police. And it was just amazing because it was just such a wonderful, it was so delicious to cross-examine on, because you just knew, like, it was just, there was no way I could have, there was no way I could have up that cross-examination, because I was just saying to her, you know, when you went to the police and you gave your statement, you told the officers that you left in a rush because you had to flee for your safety, and you took some of your own documents and your clothing. Is that correct? Yes. Did you tell the officer anything you took from that belonged to my client?
It was an even better moment, but finish. Yeah.
And she goes, I no, why would I do that? Well, do you remember taking anything from my client?
Remember, so then we had messages.
Giggle.
He swapped keys with her because he needed a fob on her key.
Well, he took it.
Yeah. So
to go deliver food to her brother's house when
I
he's
know.
sick.
So he's doing her a favor, and he swapped their keys so that he could do the favor easier. Mm-hmm. She goes, "You're so entitled," and
in
she's
a message, like,
what the WTF? She corrected you. He's like, "What the?" And he's just like, that is not your property, or something like that. He's like, you have no right to my property.
What gives you the right to think that everything belongs to yours? That's not your property. You have no right to this property. You didn't even ask my permission of it. How dare you do this? You can't just take other people's property.
And then you say,
well, did that apply to the documents you stole from my client?
Yeah.
It was like, it was so bad. She just stepped into everywhere she went, and it was so much fun.
Yeah.
But here's the wealth, and this is where it was a carefully orchestrated defense and family law case where we knew we were going in tandem, working in the right direction, because we knew what the play was here. We knew what was going on.
Right.
And this complainant couldn't but help themselves because they were just a greedy, lying individual.
Yeah, it was interesting because most of this case was what could be seen as sort of narrative evidence.
Right.
But it became highly relevant because the entire narrative behind the accusations was that our client became extremely controlling with a specific cultural mindset about ownership over women.
Right.
Mm-hmm. And that
was the premise.
That was underlying the claim that she should be believed.
Exactly. On the sex assault allegations. That was the impetus for the sex assault.
And then all the external evidence, not just our client's testimony, but all the external evidence showed that he was the one who was being abused. He was the one being controlled. He was walking on eggshells. He was
passive.
He was
apologizing.
Remember? Do you remember? Would you agree that, you know, my client was passive? She looks all confused. Passive? What do you mean by passive?
Yeah.
You have a university degree in social work.
And what do you mean by passive?
You don't know what passive means? Then you didn't have to explain what it meant. She ultimately agreed that, yeah, okay, he's passive.
This is what we deal with, right? Yeah. But it underscores the importance that when a client approaches a criminal lawyer coming out of a divorce or a relationship where you have to deal either in the civil context or the family law context, that there has to be a coordinated effort, and that the material that you get from the family law system, or in one of those cases we had the civil process as well, it is incredibly important. And, you know, it's not inexpensive. It's expensive to do this, but it God willing, gets you to the right direction and to the right place. And when you don't do it properly, it can be devastating.
What was it you say? This is a marathon, not a race.
Not a sprint.
Not a sprint.
I mean, you know, so many people come in and they say, well, you know, how soon can we get this over? And I'm like, you know, you're looking at 3 to 5 years if God forbid convicted. This is a long process. So I say it's a marathon, not a sprint. You got to pace yourself, and you got to find things to get yourself and go to work, exercise.
And take care of yourself.
Take care of yourself.
That's what we said the other night to a potential. So focus
I know,
on you now.
Yeah, no, and we made the point too, is like, in terms of the time, it's like you need that time, right? Because he was so angry and so focused on things that aren't relevant to the criminal charges, just focused on things that annoyed him about the marriage. It was like, be happy you have this time, because you need to work through it, your stress, work through your depression, your anger, whatever it is.
You're
that's
not ready
going on
for
with
a criminal trial,
right? Exactly.
It's a hard process, but I mean, I think I've said this before. It's on our website. We try and explain it to clients, but but especially for those that have charges coming out of a long-term relationship or divorce, there has to be a coordinated approach to deal with this. Otherwise, it can lead really to problems and to convictions.
And when it's done well, it turns into a fantastic cross-examination.
I know. Well, thank you. But,
and an acquittal.
well, these are all judge decisions,
Well, we've
so
had
we
some
have
of
to.
those already.
Yeah, we've had
There's
tons
one
of
we're
them.
still waiting for.
Right.
There's one or two we're still waiting for, but it's and you know what? It also it's sad because when you cut through all of this, aside from us doing our job properly and finally winning, you know, there's damage to everybody.
It's
and our
emotion.
client,
It's
the money
emotion.
that they spend, the emotional trauma, and everything else. And it's a shame that this is the way things have to play
And
out.
what I always say is, like, as much as quite often the man is hurting, because it's usually the female who gets custody and the man's cut off when that happens.
Yep.
But not always. We've had female clients who are in that situation.
The biggest loser is the children.
Of course.
Always.
Children are weaponized.
Fortunately, in this case, children weren't weaponized, but because they didn't have any.
Yeah.
But there's that other one we're waiting for a decision on where it was very clear.
And all that money spent in the civil and the family court and the criminal procedures, that could all have gone to the children.
Of course.
And in the meantime, the children are denied access to one of their parents. This is just so sad to me.
So the takeaway then is, if there's a family law element to it,
Always hook up the client with a family lawyer that we trust.
and get out in front.
Right.
Get out in front of this, and don't let it just happen.
Right.
And don't act impulsive, you know, like the,
You know what? That's enough. We're going to drone on for one more second. It's so important, and we try and get this across, and it's hard. Don't act impulsively, because that can undermine what you want to do.
It's an emotional time. Emotions aren't going to help you.
Guys, good discussion. Thank you. Until next time, like, share, subscribe, click notification. Have I got them all right?
you got them all.
That's the first time in, I think, 2 years or 2.5 years I actually got that right. Cheers
Leave
to me.
comments, everything, all right?
All right. Take care, everybody. Thank you for viewing.